Dear fellow citizen, one of the part of directive principle and state policy is going to be analyzed before you today. The directives, however, differ from fundamental rights contained in Part 3 of the Constitution or the ordinary laws of the land in the following respects. While the fundamental rights constitute limitations upon state action, the directive principles are in the nature of instrument of instruction to the government of the day to do certain things and to achieve certain ends by their action. The directives, however, require to be implemented by legislation so long as there is no law carrying out the policy laid down in the directive. Neither the state nor the individual can violate any existing law or legal right under color of following a directive. The directives are not enforceable in the court and do not create any justiciable rights in favor of the individuals. From the standpoint of the individual, the difference between the fundamental rights and the directives is that between justiciable and non-justiciable rights, a classification which has been adopted by the framers of our Constitution from the Constitution of Ayr. Thus, through the directive under Article 43, enjoins the state to secure a living wage to all workers. No workers can secure a living wage by means of an action in a court so long as it is implemented by appropriate legislation. In other words, the courts are not competent to compel the government to carry out any directive, as for example, to provide the free compulsory education within the time limited by Article 45 or to undertake legislation to implement any of the directive principles. It may be observed that the declarations made in Part 4 of the Constitution under the head Directive Principles of State Policy are in many cases of a wider import than the declarations made in Part 3 as fundamental rights. Hence, the question of priority in case of conflict between the two classes of provisions may easily arise. But while the fundamental rights are enforceable by the courts, Article 32(2) and 226(1), and the courts are bound to declare as void any law that is inconsistent with any of the fundamental rights, the directives are not so enforceable by the courts, Article 37. And the courts cannot declare as void any law which is otherwise valid on the ground that it contravenes any of the directives. Hence, in case of any conflict between Part 3 and Part 4 of the Constitution, the former should prevail in court. The foregoing general proposition laid down by the Supreme Court in 1951 must now, however, be read subject to a major exception. Article 31C, introduced in 1971 and expanded by the Constitution 42nd Amendment Act, says that though the directives themselves are not directly enforceable in the courts, if any law is made to implement any of the directions contained in Part 4 of the Constitution, it would be totally immune from the unconstitutionality on the ground of contravention of the fundamental rights conferred by Article 14 and 19. This attempt to confer a primacy upon the directives as against the fundamental rights has, however, been foiled by the majority of the Supreme Court in the Minervaville case in two respects. It has struck down the widening of Article 31C to include any or all the directives in Part 4 on the ground that such total exclusion of judicial review would offend the basic structure of Constitution. In the result, Article 31C is resorted to its pre-1976 position so that a law would be protected by Article 31C only if it has been made to implement the directive in Article 39B to C and not any of the other directives included in Part 4. It has been also held that there is a fine balance in the original Constitution as between the directives and the fundamental rights, which should be adhered to by the courts by a harmonious reading of the two categories of provisions instead of giving any general preference to the directive principles. It is also to be noted that outside these two fundamental rights in Article 14 and 19, the general proposition laid down in 1951 shall subsist. Thus, by way of implementing the directive in Article 45 to provide free and compulsory education to children, the state cannot override the fundamental rights under Article 31 of minority communities to establish educational institutions in their own choice. It has been held that the fundamental rights and the directive principles are the two wheels of the chariot as an aid to make social and economic democracy a truism. This is all about today's part of directive principles and state policy. Thanks, regards.